COVID-19 and urgent requirement of the invention, vaccination, brings my mind to highlight the importance of the invention, particularly employees' inventions and fair and reasonable remuneration. We need to keep in mind that the law and economy have a direct relationship and are complete with each other. Particularly for developing countries, it's a significant motivation source to pay fair and reasonable remuneration to employees for their inventions. Based on my best knowledge, it is the first dispute that was brought before the court and arbitration. I am Aysel Korkmaz Yatkın. I specialize in intellectual property with particular focus on patents and utility models, and I am the chair of Insurance and Reinsurance Practice Area. In 2020, an arbitration judgment was held per the ISTAC serial arbitration procedure regarding the compensation remuneration request for employee invention. Before going into the details of the case, I would like to note that the employer company had requested full rights ownership for the patent from the employee who invented an invention at that time. Therefore, the employer duly asked the employer to pay the fair and reasonable amount according to Articles 22, 24, and 25 of the Decree Law No. 551, which was in force on the full right ownership request date, and Article 1.5 of the IP Law. The employer made several verbal and written requests for the payment of a reasonable amount, but the employer sent no positive responses even after this very well-deserved request. The employee's employment contract was terminated by the employer following 17 years of working time. Following these developments, the employee filed an indefinite damages claim for the determination and compensation of a reasonable and fair amount before the IP court. Although it is understood from Article 115 of the IP law, compulsory arbitration is not clearly stipulated, but Istanbul IP Court dismissed the case based on arbitration objection arising by the employer's side. Upon the decision of the Istanbul IP Court, an arbitration process was initiated by the employee who had no other option to apply for the arbitration before the ISTAC. It was decided by the arbitrator appointed for the resolution of the dispute to implement the regulation, which includes the current regulations. The arbitrator transferred the case to the expert panel to evaluate the dispute and employee's remuneration request. The expert report, it was concluded that the employee was an inventor and legally entitled to remuneration, and the employer's product could not have been released to the market without employee's invention, and the economic value of the patent was quite high, and the employer sold the product with very high profitability, and they earned a very high profit out of the invention. However, due to the application of extremely mixed price determination criteria in the regulation, it was determined that the compensation to which the employee is entitled is an amount that cannot even cover the expenses of the arbitration procedure. The arbitrator conducting the arbitration proceedings concluded that the amount determined by the regulation is not in line with the provisions of the IP law, considering all of the conditions of the concrete case, and that the formal calculation method, which does not comply with the expression and the definition of the reasonable amount. In this context, the arbitrator increased the amount determined under the implementation of the regulation by 5 times per principle of equity. The determined amount is proportional to the profit obtained by the defendant employers from the patent and not proportional to the minimum level of labor and expense required in applying to the litigation to get the right. In other words, the arbitrator realized that the provisions of the regulation to be applied to the resolution of the current dispute cause meager remuneration to the inventor against companies that they earned high profits. You can find more information on this topic in our thought leadership paper for this year. Thank you for listening to me.